Welcome to the deep dive. We dig into the sources you're curious about and, well, pull out the key knowledge you need. Think of it as your quick way to get up to speed.
And today we're getting into an article by Larken Rose called Interpretation versus Fabrication.
Right, our mission. To really unpack his argument, he claims that a lot of what gets called constitutional interpretation here in the U.S. isn't interpretation at all.
He calls it fabrication, basically a way to stretch federal power,
Yeah.
way beyond what the Constitution originally set out.
And this matters because, well, understanding where government power supposedly comes from and all the arguments around it, that's pretty fundamental stuff.
Absolutely. Rose's piece, it's definitely provocative. It really pushes you to think hard about how the Constitution is used, or maybe misused, as he'd say.
He questions if the justifications for federal actions actually, line up with the document itself.
Or if they're just convenient stories, narratives built to serve political goals. That's his core accusation.
Okay, so let's get right to it. His main thing is this clash between legitimate interpretation and, well, fabrication.
Yeah, and he uses these pet turtle analogies to make the point really clear. They're quite memorable, actually.
Oh, yeah. Walk us through those. Turtles.
Okay, so first he says, imagine the sentence. Today, I ate a salad with my pet turtle. Simple enough.
Right. Could mean you shared your salad, or maybe the turtle was part of the meal. A bit grim, but okay.
Exactly.
Eh?
Both readings kind of fit the words, depending on context. Then, example 2. I only feed my turtle salads.
Okay, so maybe different kinds of salads, greens, veggies, whatever. Still makes sense. The meaning is, contained.
Precisely. It's interpretation within reasonable bounds. But then he throws the curveball.
This is where the fabrication comes in.
This is it. He says, what if you interpret I only feed my turtle salads to mean I feed my turtle felons?
What? That makes no sense. There's no connection.
Exactly his point.
Yeah.
He says that's not interpretation, it's pure fabrication. You've completely invented a meaning that has no basis in the original words.
And that's the analogy he applies to constitutional law.
That's the core of his critique. He argues that many legal arguments presented as interpretations are actually like saying salads means felons. Illogical leaps, constructed justifications.
Ugh. Okay, so he doesn't just stick with turtles. He uses a major Supreme Court case to really hammer this home. Wickard v. Filburn.
A really significant one.
For those of us maybe not up on our 1940s case law, what happened there, and why is it Rose's prime example?
Okay, so Wickard v. Filburn, 1942. You had this farmer, Filburn, growing wheat. Crucially, it was just for his own use.
Like on his farm, for his animals, his family.
Exactly. It never left his property, wasn't sold, zero interstate commerce involved in the traditional sense.
Okay, so how did the feds get involved?
Well, the Supreme Court ruled that even this activity fell under federal regulation, specifically the Commerce Clause.
Wait, how? If nothing was being bought or sold across state lines?
Here's the reasoning they used. They said, well, if Filburn hadn't grown his own wheat, he might have bought wheat on the open market.
Might have.
Right. And that potential purchase, or lack thereof, could, in aggregate, affect the overall interstate market price and demand for wheat.
Okay, wow. So a potential action affecting a potential market fluctuation that counts as interstate commerce.
According to the court in Wickard, yes. And this is exactly where Rose jumps in.
I bet. This sounds like his feeding turtles felons example come to life.
That's precisely how he frames it. He calls the Wickard ruling a blatant fabrication.
Okay, before we go further, maybe just quickly, the Commerce Clause, what's the basic idea they're supposed to be?
Sure. It's in the Constitution, Article 1, Section 8. It basically gives Congress the power to regulate commerce among the several states.
Yeah.
The original idea was mainly to prevent states from setting up trade barriers against each other and to create a unified economic space.
Got it. So keep trade flowing between states.
Right. Now back to Wickard. Rose argues the court took commerce and interstate and just redefined them beyond recognition.
So growing wheat for your own chickens suddenly becomes interstate commerce.
In his view, yes. He thinks they stretched the words so thin they became meaningless, essentially giving the federal government a blank check to regulate almost any economic activity, however local.
So for Rose, this wasn't interpretation. It was.
A complete rewrite. A fabrication designed purely to expand federal power, especially during that New Deal era when these kinds of questions about federal reach were really intense.
And he argues this wasn't just a one-off thing, right? He sees this pattern continuing.
Oh, definitely. He makes a point of saying this isn't a partisan issue in his eyes. He believes both Democrats and Republicans engage in this kind of constitutional fabrication.
Really? Both sides using made-up interpretations to get what they want.
That's his claim. He suggests Democrats might stretch interpretations to justify federal action on things like, say, healthcare mandates or certain gun control laws or maybe big social programs.
Okay. And Republicans.
On the Republican side, he might point to things like expansive federal immigration enforcement or the war on drugs, arguing that the constitutional justification for the scale of federal involvement there is pretty thin based on the actual text.
So different goals, same method of creative interpretation as he sees it?
Exactly. And he argues the common victim in all this is a specific part of the Constitution.
Which part is that?
The 10th Amendment. The one that says any powers not specifically given to the federal government by the Constitution, nor prohibited to the states, are reserved to the states respectively, or to the people.
Ah, the states' rights amendment, essentially.
Pretty much. Rose argues both parties routinely ignore or twist interpretations to let the federal government muscle in on areas that should belong to the states or individuals under the 10th Amendment.
He brings up a more recent example, too, involving the Trump administration, right? The Alien Enemies Act.
Yes, that's another case he uses to illustrate the point about fabrication.
What happened there? How does that fit his argument?
Well, the administration tried to use the Alien Enemies Act of 1798 to deport certain immigrant gang members.
Okay, an old law. What was the argument?
They argued that a street gang, like MS-13 for example, could be considered agents of a foreign nation, and that their activities constituted an invasion or predatory incursion under the terms of that act.
Equating a domestic gang with a foreign invasion.
That's the leap Rose points to. He sees it as another clear fabrication inventing a meaning to fit a desired outcome. The law was originally aimed at citizens of hostile countries during wartime.
Right. Wasn't that law used during World War II?
Controversially used for the internment of Japanese Americans. That history itself shows the potential dangers of stretching its meaning.
And did the courts buy the gang as foreign invader argument?
No. As Rose notes, even a Trump-appointed judge rejected that application of the law as inappropriate, which, for Rose, just reinforces his claim that it was a fabricated legal basis, not a real interpretation.
So it kind of underscores his point that these aren't legitimate interpretations, even when pushed by those in power.
Right. It touches on complex issues like national security, sure, but Rose would argue even those don't justify twisting the original meaning of a law like that.
Okay, so stepping back, what does Rose see as the ultimate driver behind all this alleged fabrication? Why do it?
His answer is pretty blunt. Power, political convenience.
Just wanting to do things and finding a way to justify it legally, even if it means bending the rules.
Essentially, yes.
Yeah.
He argues interpretation has just become a tool for political goals. Both parties, he says, create this kind of legal mythology, these fabricated stories, to justify centralizing more and more control in Washington.
And he takes this quite far, doesn't he? Mentioning specific federal agencies.
He does. He suggests that, based on his reading, which is very much an originalist one, trying to stick to the supposed original meaning agencies like the ATF, the DEA, even the FBI in their current scope, lack a solid constitutional foundation. He sees them as outcomes of this long process of fabricated interpretations piling up over time.
Wow, okay. That is a strong claim. It really questions the legitimacy of a lot of the modern federal government.
It does. And, it rests heavily on the idea that there's a single, clear, original meaning that we can perfectly access and apply today, which is itself a big debate in legal circles.
Right, the whole living document versus original intent debate.
Exactly. Rose falls squarely in the original intent camp and sees deviations as fabrications.
Okay, let's try to pull this all together. What are the absolute core takeaways from Larken Rose's article, as we've discussed?
Well, first, the key distinction he makes. Genuine interpretation, trying to understand the text as intended, versus fabrication, which is just inventing meaning for convenience.
Got it. Interpretation good, fabrication bad, in his view.
Second, his main claim, that the U.S. government, across the political spectrum, routinely fabricates constitutional meaning.
Not just interprets wrongly, but actually makes stuff up.
That's his assertion. And the goal, he says, is always to expand federal power beyond its original constitutionally limited scope.
And we saw his examples, Wickard v. Filburn stretching commerce.
And the attempt to use the Alien Enemies Act against gangs by redefining invasion.
So ultimately, he's calling for a serious rethink of how the Constitution is treated.
Yes, a reevaluation of interpretation itself, and maybe more critically, questioning the motives behind the interpretations we're given. Though, again, it does raise that counter question. If the Constitution is meant to endure, doesn't interpretation sometimes have to evolve?
That's the tension, isn't it?
It really is.
So wrapping up our deep dive into Larken Rose's interpretation versus fabrication, the big takeaway is his stark argument. He believes much of what passes for constitutional interpretation today is actually just made-up justification.
Right. Invented meaning used by both Democrats and Republicans, he argues, to grow federal power way past what the Constitution originally allowed.
It's a challenging perspective, for sure, and it really forces you to look at legal arguments and government actions and ask, okay, where does this authority really come from?
Is it grounded in the document? Or is it, as Rose claims, a convenient story? It has huge implications for how we see the legitimacy of government power.
Which brings us to a final thought for you, the listener, to chew on. If that line between interpretation and fabrication is as blurry or as frequently crossed as Larken Rose suggests, what does that actually mean for how legitimate we perceive governmental power to be in the United States? And what are its real limits if the rule book itself can be effectively rewritten through interpretation?
A heavy question to ponder. Definitely food for thought, and maybe worth checking out Rose's article directly if this sparked your interest.
Indeed. Thanks for joining us for this deep dive.